And then number 10, this is an interesting case. The Board of Immigration Appeals concluded, I'm sorry, not the board, but this is some sort of case. So I'll read it. It's a false claim to citizenship case. Immigration granting okay, so they granted a petition for review of a decision of the Board of Immigration Appeals and remanded. The panel concluded that Ramirez, the applicant's misrepresentations about his citizenship to police officers for the purpose of avoiding removal proceedings did not render him inadmissible and therefore ineligible for adjustment of status under 8 U.S.C. Section 1182, for falsely claiming U.S. citizenship for any purpose or benefit under law. The panel explained, and I think this is the Ninth Circuit. Let me double check. This is kind of amazing. Yes, Ninth Circuit. Ephraim Ramirez Munoz v. Merrick Garland, Ninth Circuit, 2023. Let me bring back my notes. The panel explained that the BIA's interpretation was incoherent in that it bestowed under, quote unquote, under, with two different meanings at once, as if the statute read, quote, for any purpose of the alien related to any law or any benefit provided by any law. The panel also concluded that the BIA's interpretation was unreasonably broad, explaining that it encompassed lying about one's citizenship with the purpose of avoiding removal proceedings, regardless of whether the lies recipient had a legal obligation to obtain citizenship information and report suspected undocumented persons to the immigration authorities. Rather, the statute would apply when an individual lies about his citizenship to anyone at all to minimize the risk of being detected by immigration authorities. The panel concluded that statutory text and legislative history show that Congress did not intend false claims to sweep so broadly. Rather, Congress' concern was with individuals who falsely claim citizenship to obtain a legal benefit reserved for citizens or to invoke a law intended for citizens, which, my words, is kind of problematic because what if you're going to get a work authorization that is entitled to green card holders, not citizens? So I didn't fully read the whole case, but it was interesting they went into this. If a case like this pops up, sorry I didn't do full research. I didn't plan to do this podcast today, but I had these notes that I didn't fully right now. I say, you know what, let's start getting this top 10 back in. But it's an important case. Is Ninth Circuit. Based on the synopsis I put here, I see some errors in the core. At least we're reserving this language about reserving stuff for citizens, which is incorrect. It kind of reminds me of the Supreme Court case that was decided, a very terrible decision decided last year, where the DMV for this one guy mistakenly registered him to vote, I think, and he didn't need to be a citizen to get the driver's license because he had an EAD, so he was entitled to it. So he wasn't trying to get a benefit under act that he wasn't entitled to. So USCIS and like the Board of Immigration Appeals both denied him incorrectly, and the immigration judge denied him incorrectly. And then the Supreme Court said, you know what, even if they're incorrect, you're out of luck, which is a crazy decision. But you know, how does that go with this and mistakes and stuff? It just makes it really messy. But an important case to learn, and I'm going to have to read it again because this kind of false claim stuff pops up, but it's on my reading to-do list. Ephraim Ramirez Munoz, Ninth Circuit. Interesting stuff.